unfortunately, when we have so much and everything laid out in India and our entrepreneurial journey over the next decade or so, why can't we have arbitrations in India? Why Singapore? Why Hong Kong? Why Dubai? Or other European jurisdictions? What's your take on it? Why India can't be an arbitration hub to the dispute?
So I don't think there is a need to, compare or compete in this area.
Okay.
I think there are, horses for courses. In my view, all of this have coexisted for a long time now, and will continue to coexist. As I said, so far as legal systems are concerned, so far as advocacy is concerned, we are possibly at par, or with due respect, we are actually better than many other jurisdictions. It's only a question of, as I said, the change in mindset, which is now pending as part of the process, and I think we are in that journey to change over a period of time.
Hello, everyone. Welcome to Candid Conversations with LegalPay. It is our endeavor to bring insights through such conversations with esteemed experts and visionaries of the industry and talk about the insolvency market, arbitrations, litigation finance, interim finance, and fintech in legal domain. We wish good health to all our viewers. Today, we are honored to have Mr. Vyapak Desai, partner and head of international dispute resolutions at ADA, one of the prominent law firms in India. He needs no introduction. Mr. Vyapak has experience in representing clients in a host of complex cases, including investment treaty arbitrations, commercial disputes, international trade, and cross-border disputes. He has been on a panel of various esteemed arbitration centers, and he's a very expressive writer and has authored his views on enforcing arbitration awards in India, published by LexisNexis in 2017. Welcome, Mr. Desai, and glad to have you with us.
Thanks a lot, Kashish, for this opportunity, and considering the importance of this subject in itself, and my personal passion and interest towards this subject, it's my pleasure to be part of this conversation, and I hope it helps a few others who ultimately listens to it.
Sounds good. Thank you so much, and we're glad to have you. There are budding lawyers in India who look up to you as inspiration, specifically within the arbitration industry. Before we begin, would like to understand about your journey within arbitration specifically over the years, how it has spanned up, and how do you see this evolving?
Sure. So if I say in a nutshell, I think when I started the practice, or I started to even practice law, forget arbitration or otherwise, I think the difference from then and now, if I may say, is that only thing we used to talk about is negatives about arbitration, and today I think in 20 years from there, I'm talking about early 2000, and now we are in 2022. So it has taken almost 20 years. But only thing now we talk about is positives of arbitration, and the opportunities which are huge as part of dispute resolution process. And I usually used to hear that arbitration is an alternate dispute resolution process, but my take on it and my proposition now is that arbitration is a parallel dispute resolution proposition rather than an alternate dispute resolution. So I think we are actually looking at it as a parallel system of dispute resolution rather than alternate, and that's the difference. I would put it in a nutshell as my journey in this field.
No, that's amazing, and I think you have summarized it in one single phrase, and it's a commendable thing, because what we understand that justice is a fundamental right for every individual or an enterprise. But we always feel that why is there a need for companies to add a dispute resolution clause or arbitration clause at the end of every contract? Why not go for the traditional route? Would love to know some thoughts on that as well from you.
See, I think situations in India we can talk in a minute, but even worldwide, right? This is not just an Indian phenomena. Worldwide, when it comes to commercial disputes, it has been well accepted, and in my view, it has been proven over a period of time that this form of dispute resolution is very effective and efficient. There are two different connotations here, which I am proposing. Right, one is the effectiveness of the dispute resolution, and there is a difference between what you get in a court litigation versus in an arbitration process, and efficiency, right, is also very different. But when it comes to India, it is even more important for two simple reasons. I think we as a community, I think we have always been a big propounder of resolution beyond a simple court system, right? For ages together.
Yes.
And more importantly, when we have 30 million cases pending in different judiciary levels, and which I heard last that post-COVID that number has gone beyond 40 million. I think it is even bigger reason that India should embrace this as a parallel dispute resolution system than the court system. Again, without taking away the respect, without taking away the importance of the court system, because the reason why they are there is very different. But when it comes to commercial dispute, if I may summarize my point, I think the effectiveness and the efficiency of it is unparalleled, and it has been proven world over. So that's the reason why I think more and more parties choose this form of dispute resolution over any other court system, which may be much better in other jurisdictions compared to India.
Very fair, very fair. And I think efficiency and quickness is something that India is evolving at a very higher pace. So I think kudos to that, and very well summarized. A couple of discussions I think has already been in the limelight for the couple of years with respect to the changes that has been done in arbitration law and practice, specifically to make it much more efficient, such as introduction of 29A. Would you like to throw some light on such amendments and how such amendments span this evolution journey even further?
Sure. So I think I would put it like there are two different aspects to arbitration, right? One is the hardware part of it, and another is the software part of it. Okay. So if I use that analogy, there are four pillars or the four hardware part of the arbitration, right? One is the law in itself. Second is the institutionalization of arbitration. So basically institutions who govern or administer those arbitrations. Third is the people who drive it, be it be lawyers, be it be arbitrators, be it be parties. That's the third part of that. And the fourth is the mindset, right?
Definitely.
So I would put that these are the four pillars or the four, parts of arbitration. And again, if we go into history, I think while we had 1996 Act, which was akin to English arbitration law or Singapore arbitration law based on unilateral model, but we lacked in this four different parts or four different pillars, the way that law was interpreted and implemented. What has changed in last 20 years is that now let's say 2015 amendments, and you talked about 29A.
Yes.
That's only one amendment, right?
Yes.
But there are several such amendments which have brought into the law to implement and execute the crux or the objective for which the arbitration law was enacted in the first place. So I think the law and the evolution of law post 2012, post the Balco judgment, and then 2015 amendments, and then 2019 amendments, has taken care of this one pillar, which is law. Second, I think India did excellently well. Immediately after we got our 2015 amendments, a high-powered committee was set up to institutionalize arbitration in India, and we are seeing some fruits of it. We know there are several good institutions which has come up in last few years, whether it is the Mumbai Center, the NPAC in Chennai, New Delhi International Arbitration Center, and many more to name. So that pillar is also in a way developing well. Third was the arbitrators and the lawyers and the parties. I think that again, in my view, there was never a dearth of good counsel and good legal support.
Yes.
It was only a question of people taking this as a priority and focusing on it, which is happening. I see a lot of students joining law to become arbitrators and arbitration lawyers. That was never the case earlier. So I think in next 1 decade, we are going to see a very different arbitration bar, including the arbitrators and counsels in India. And the fourth is obviously the mindset. I think we need to do a little bit more on that. But again, it's a question of journey. It doesn't change overnight. And I'm sure the problems that today we are facing is more of mindset than the first three problems that I was talking about.
Yes.
On the soft part of it, I think there are two aspects to arbitration. One is party autonomy, and second is flexibility. I think party autonomy is taken care of law substantially. You see, most of the provisions talk about subject to agreement between the parties. Appointment of arbitrators. Law is going more and more in favor of the agreement between the parties, even with regard to seat and the fallout of choosing a seat, including the recent judgments on emergency arbitrations and stuff like that, which Indian law never acknowledged as part of that law. Jurisprudence is acknowledging that this is nothing but party autonomy. So I think that is something which, in my view, is a very, very positive sign. And second is flexibility, right? And that also, in my view, I think people are gearing up to the advantage of it and using it as part of their contracts and as part of the clauses in the contracts where that flexibility is retained and implemented well. So I would, though it's a little longer, response to a question on 29A, but I thought it might be a good idea to understand the broader aspects of it.
Yes, thank you so much. And I think that actually details down how the journey has been. And I personally feel that there is a phenomenal wave going out in India for the made in India, do it India, build in India concept. And definitely when you have so much and everything made out in India and our entrepreneurial journey over the next decade or so, why can't we have arbitrations in India? Why Singapore? Why Hong Kong? Why Dubai or other European jurisdictions? What's your take on it? Why India can't be an arbitration hub to the dispute?
So I don't think there is a need to, compare or compete in this area.
Okay.
I think there are, horses for courses. In my view, all of this have coexisted for a long time now and will continue to coexist. I don't think it is about taking away something which is happening in Singapore or Hong Kong or Europe
Yep.
I think there is enough to chew so far as India is concerned. As I was telling you, there are 13 million cases pre-COVID pending in Indian courts. And the reason why, or the reason as to, such pendency has also resulted in a situation where many cases don't even come to courts.
Yes. Yes.
So I think if we are able to develop a robust, parallel dispute resolution system, I really don't see any kind of a competition there. I see there is a great sense of coexistence in this area. And as I said, so far as legal systems are concerned, so far as advocacy is concerned, we are possibly at par, or with due respect, we are actually better than many other jurisdictions. It's only a question of, as I said, the change in mindset,
yes,
which is now pending as part of the process. And I think we are in that journey to change over a period of time.
Sounds good. And I think that you have summarized all of it in a fashion that it's the change of the mindset that's pending. Would love to hear your views, since you have worked with so many international funders, specifically third-party litigation funders providing financing during such arbitration practice. How do you see third-party funding spanning out in India and pushing the efficiency of the court and the entire processing to enable justice? How do you see that spanning up? Not now, I mean, there's a wave that has already been elapsed, that's been continuing, but going forward, what's your take on it?
Sure. See, I think it's a matter of, clear commercial demand and supply, right?
Yeah.
Why would someone, litigate in the first place?
Yeah.
And then, why would you need third-party funding in the second place, right?
Exactly.
I think we are talking about pure, commercial disputes.
Yeah.
It's a pure question of expectations in the eyes and minds of people who are in those disputes. And there was a situation where there was a conflict in expectations between those parties, and therefore they have reached to a situation where there is a dispute between them. And I'm at the moment restricting myself to the commercial disputes.
Yes.
And if there are legitimate claims like that, then why not fight it out or litigate them or arbitrate them? And for which, if you are not able to do it for a simple reason like non-availability of resources, and it can be of any form and manner, including financial resources, then to supplement those is again a very legitimate reason to support that kind of situation. From an Indian perspective, this was never a illegal issue or problematic issue. There are many different jurisprudence and policies in different jurisdictions, but from an Indian perspective, this was never a problem. I think from a third party funding or litigation finance perspective, I think India was not able to develop was just because of the systemic reasons, rather than legal reasons. And once we overcome some of these systemic reasons, including not only making the process efficient of dispute resolution, but more importantly, the enforcement part of it. I think that is one area. I think that is one area where we need to do a little bit more. And I have some thoughts on it, but I can give that a little idea now, or maybe if you have any other question.
No, definitely would love to hear your thoughts on the.
But see, I would put a very loose analogy around this, right? If you see our whole liquidation process. What was liquidation process, right? It was also recovery of monies.
Exactly.
And we used to again hear in early 2000 and late 2000 that hardly any company was which had so much of potential was rightly wound up or lightly liquidated. And in other countries, you had bankruptcy code, you had restructuring codes, you had Chapter 11 and Chapter 7 and many other provisions under different law which restructured failed companies because and they used to in fact become very successful company after restructuring. I think what happened in India is that everything was getting stuck. Under at one end it was only the Companies Act which provided liquidation process, but on the other hand there were several different acts which were applicable, and there was a lot of conflict. By simply bringing in the insolvency code, IBC, and doing one very important change. The official liquidator, which was like one person office dealing with thousands of companies, was changed, and we privatized liquidation, right? In a way that was, in my view, a great example of how judicial or even administrative or quasi-judicial powers or responsibilities can be privatized in a more legitimate fashion. And what has happened, it has bring in efficiency on liquidation, and that has led to so many different opportunities. Whether it is restructuring, new companies coming over, taking over old companies, litigation funding, so on and so forth. I think what is the need now, and I'm coming to the point, is on the enforcement and execution part of it. I think in some way there is a big roadblock because of the procedural problems in execution, which is not so much of a judicial function compared to the other judicial functions that one would imagine. So I think there is a need to change the perspective on execution. If we are able to use the example of IBC and maybe let's say appoint professionals to execute awards and judgments, and make it little more administrative, subject to oversee of courts. Obviously we need judicial bodies to oversee that process, but we don't need it to get clogged in the system of judiciary. I think if we are able to do this one simple change, then we have already seen one example which is sufficiently successful example. I think third-party funding will grow phenomenal. I think that's the only roadblock I see. And it's possibly easy to tackle that problem as well.
Sure. Thank you so much, Mr. Desai. Lovely having you with us, and we look forward to have you back with us some other time, but definitely we love expanding your thoughts on how the change of a simple mindset is required. And it's the entire three pillars who are working perfectly fine. It's just about how you change and bring that smaller change into the system. Thank you so much, Mr. Desai, for having with us and taking our time. Wish you all a very best of the health, and all our viewers a very good and safe health. Hope we come out of this pandemic much stronger and smoother. Thank you so much.
Thank you. Thanks, Kashish, for having me.
Sure.
Thank you.
Thank you.